This is HubWonk. I'm Joe Selvaggi. Welcome to HubWonk, a podcast of Pioneer Institute, a think tank in Boston. Despite reporting daily delays, closures, and accidents, the MBTA begs the exasperated public's patience, assuring all that its current culture of transparency and accountability will soon rectify decades of neglect. But has the culture at the T really changed? To wit, after submitting to and receiving an arbitration award with its largest union for its retirement fund, the MBTA refused to release the award details to the public. The public's concern over the T's retirement fund centers on the $1.4 billion gap in its obligations to its present and future retirees, all of which risks falling to the taxpayers absent substantial reforms to its structure. After receiving a public record request from Pioneer Legal, a public interest law firm, a week after the award was produced, the T resisted releasing the document for another 7 months. This record denial persisted despite Pioneer Legal's additional request to the state's supervisor of records and a suit in Superior Court. It was only after a petition to a single judge on the appeals court that the MBTA released the award document, finally giving the public access to arbitration results for a public agency. This lack of transparency regarding a $1.4 billion potential public liability casts doubt on whether the culture at the MBTA genuinely embraces the notion of accountability. How can riders, taxpayers, and policymakers trust the T's leadership when the T's leadership is demonstrably reluctant to release important documents to the public? My guest today is John Liberte, the attorney for Pioneer Legal, who spearheaded the struggle to have access to the MBTA's arbitration award. John will share how his 7th-month struggle to gain access to a public document was met with indifference, specious legal defenses, and procedural dead ends, and how the tireless temerity of Pioneer Legal led the MBTA to ultimately release the award details to the public. When I return, I'll be joined by attorney for Pioneer Legal, John Liberte. All right. Okay, we're back. I'm Joe Selvaggi, this is HubWonk, and I'm now pleased to be joined by attorney for Pioneer Legal, John Liberte. Welcome to HubWonk, John.
Thanks for having me, Joe.
Well, it's terrific to have you here from Pioneer Legal. We're recording not long after a lot of hard work on your part. You had spent a lot of time trying to get information about the arbitration agreement between the MBTA and its main union, the Carmen's Union. I want to make sure I have the right legal term. It was an interlocutory appeal of the denial of a motion for an order requiring compliance with the public records law. So I'll get that out of the way early on and make sure we use the proper terms. But before we dive into the topic of today, let's let you share with our listeners. You're only the second guest from Pioneer Legal on HubWonk. Tell us a little more about Pioneer Legal's mission and some of your work there.
Pioneer Legal is our the name that we're operating under is Pioneer Public Interest Law Center. Is a public policy law firm, public interest law firm, geared toward a government accountability, transparency, responsible government, advocating for the constitutional, both federal and state rights of individuals who might not otherwise have a voice because of the economics of litigation and the like. So we're advocating for the small guy and trying to keep government transparent and responsible to Commonwealth voters and voters throughout the United States.
That sounds like a good cause. As you say, advocating for the little guy against the biggest of all big guys, state government, federal government. So it's a David and Goliath. But for your work, these smaller interests would not have a voice in the legal system. So we're thrilled to be part or connected to Pioneer Legal. All right, we're going to talk about your request that is ultimately granted for access to the agreement between the MBTA and its union about essentially how their pension is run, how who pays into it, when they can retire, when they leave. This is something that was decided back in August of 2022, almost a year ago. and you've spent a long time trying to get access to it. So I want to unwind all the details because this was a lot of work, and I think it has a substantial source of interest for our listeners. We do talk about the MBTA law, and this is a big part of it. So let's start at the beginning. Pensions are a bone of contention, I'm sure, for all unions, all workers. How does it normally work between the union and something like the MBTA? Is arbitration always the case, or do from time to time they come to an ordinary agreement?
My understanding is it's not uncommon to be forced to get to arbitration, but I know historically the local 589 in the MBTA have reached a series of collective bargaining agreements relative to the pension plan, but we're unable to do so during an extended period of time, running from 2018 forward. And that necessitated by agreement by both the union and by the MBTA to select an arbitrator, Ms. Neumeier, as a decision maker once they reached an impasse, and that occurred in 2022. We know that there was a series of hearings over several months, and ultimately she issued an arbitration award dated August 23rd, 2022.
So John, I just want to unpack, I want to, for our listeners' benefit, just in case they're not familiar with this concept, you have two sides that reach an impasse. They don't see any way to ultimately agree, so they go to what we hope is an arbitrary, an objective third party, one that has neither side's interest. Forgive me if this is a generalization, but it's almost like a trial where you have a defendant or a plaintiff, and you are sort of making your best case to this arbiter who decides who's got the better case. Roughly speaking, is that the concept behind arbitration?
Yes, it's a private litigation, unlike one in a superior court or whatever, but it's typically in a private. But it is litigation. Evidence is submitted. There is testimony by witnesses, and the arbiter is essentially a private judge who the parties have submitted or agreed that person will make a final decision on their pending dispute and will issue a judgment or an arbitration award in this instance. That's correct.
That's right. So you have a judge and they make a decision, and in theory, everybody's got to live with that decision. They, as you say, they made their best case. I actually have access to it. It came out 2 days ago, so I was actually intrigued to read it, and really, really good stuff. I'm impressed by, as you say, Ms. Neumeier's, thoughts and conclusions. So let's go a little bit deeper. When there's hardly a day that goes by where we don't read something about the T's dysfunction. Let's, on a high level, why do you think so? They had this agreement. It was developed, as you say, back in August 26th. But obviously, the T knew about it. The union knew about what the arbiter had decided, but nobody else did. It was sort of it wasn't available to the public. Let's start from the abstract. Why do you think the public needed to know what the determination of the arbitrator was?
Why I can know at least why Pioneer Institute and Pioneer Legal were seeking production of the arbitration award was it's well publicized, the dysfunction of the MBTA, and the fact that, even since set forth in the award, that there's an underfunded pension liability of close to $1.4 billion. The fact of the matter is that there's more money being paid out to retirees of the MBTA than is being paid in at this point. And any deficit that is underfunded would have to come from the Commonwealth, meaning you, me, and any other taxpayer in the Commonwealth. And the thrust of the public records request was to get access to this arbitration award and determine, because what occurred chronologically is the arbitration award was issued. Pioneer Institute submitted its public record request within a matter of days, within a week of gaining knowledge of the arbitration award. And then shortly thereafter, Local 589 commenced a lawsuit in Suffolk Superior Court seeking to set aside the arbitration award.
Oh, so John,
And-
let me let's take that one piece at a time. So what we're talking about is the reason all of our listeners should care what was in that agreement. Is that as it currently stands, the difference between what the T owes to its workers in their retirement and what the T has to give them, and as far as current money and future money that they intend to collect, is about $1.4 billion. And without proper, let's say, fixes, that bill will shift to the taxpayers. And as you say, that's $1.4 billion less to spend on other important things like schools or infrastructure, right? This is a huge number that we should all our listeners should care about. And at the very least, if the T is trying to sort out its problems, the public who's underwriting these problems should know what's going on. Is that a fair characterization?
Very fair statement. Yep. Yeah. And so, as you alluded to, it's what is going to, in the arbitration award, how was the negotiations or award setting different rights of either the workers or the MBTA to help manage, in part, what the underfunded liability would be, and how was that going to be dealt with prospectively. And as you'll note, in the arbitration award, there was a significant decision or ruling in that award where the arbiter changed the arbitration or the retirement age of certain retirees from age 55 to 65 as a way of delaying payouts to potential retirees, and inserting a penalty, if you will, or a 6% reduction in retirement amount if they retired before age 65, which is a completely different change than what had occurred in the past, where the retirement age had been 55. So I don't have any independent verification or knowledge of current negotiations, but there was a news report last month from the Herald indicating that notwithstanding that being a victory, if you will, for the MBTA in the arbitration award, subsequent to the issuance of that award, the MBTA and Local 589 continued negotiations, and if the reports are true, that win for the MBTA on that particular issue is no more, and it's back to the age 55 retirement age. And so
so hold on, John. I just want to unpack it for so I don't want to jump ahead and come to current events. Let's linger a little bit on how we got from this arbitration award, which was, as we set out on the outset, you agree to arbitration, and then you also agree that whatever the arbitration determination agreement is, you live by it. And as you say, not long after that, everything was agreed upon, the union said, even though we agreed to arbitration, we're not happy with the result. I read the judgment, and it seemed to be very, very friendly to the union's interest, meaning, look, you guys make a heck of a case for against the MBTA that you should get your request honored, but the arbitration person had as her mandate that they had to consider the dire economic circumstances of the T, meaning all things being equal, we just went through a pandemic where ridership went down by something like 90% and costs went up, I think, only by 6%, but up is up, and that there's this whole gaping hole in the system. That to me was what was supposed to steer this arbitration in one direction or another. And again, this problem with the pension fund was really not a values or power. It was just math and actuarial thing. And she was mandated to take into account not just that dire straits of finance and all, but she was also asked to look at other public pension management systems and other public transportation systems. So she looked at the rest of the state and their pensions, and she's looked at other cities and their mass transit, and she said, hold on there, were good in some ways and really bad in others. To me, she really took the time to consider each aspect. And the one glaring difference between our T's pension and everybody else's is the retirement age. So say more about, you said some people were, we move retirement 55 to 65. Say more about why that's so important, or why that's such a bone of contention with the union.
It's reminiscent of what we're seeing in France. You extend the age, you're going to have to work longer to vest, if you will, and get your full pension if the age had been set by 65. And what that does is extends the period of time where workers are contributing to their own retirement, and also delays money coming out of the pension fund at the same time. So what accomplished is, in part, it's not the complete Band-Aid, but it is a tool whereby it would address the underfunded status of the pension, which we now know to be about $1.4 billion. So in essence, what you're doing is keeping more money going in as workers are extended and their retirement age is extended, and also keeping that money in for a longer period of time, and hopefully return on investment and more worker coming back into the MBTA workforce. We start to address the underfunded status and less state contributions as a result.
Yes, again, this is an important point. Those people who ask for my advice as far as financial planning, when they ask questions like, when should I take Social Security, or when should I start taking for my retirement? It's a double whammy if you retire early. It's not just merely that you've had less time to put money into your nest egg. It's that you're pulling it out earlier and you've got a longer retirement. So if you work for 30 years and you have to support 30 years of retirement, that's a tough nut to crack. If you work for 40 years after retirement, collect for 20 years of retirement, the math seems to work. I think that's what you're saying. It's just a simple fact that the MBTA needs expertise. It needs its workers. It's shy on workers right now. If they were to be asked to work till 65, which is, as we get healthier, it seems like a reasonable thing. They'd be contributing 10 more years and they wouldn't be withdrawing 10 more years. And frankly, they'd have, actuarially speaking, 10 less years of retirement, right? That's the basic contours of the math. So let's back up a little bit and say, okay, look, whether good or bad, or whether everybody's happy, why do you think the T would come to the table, have an arbitration agreement, and then keep that arbitration agreement secret? I mean, that's at the essence of our question. If everything else were true and nothing else were changed, and they simply released the results of the arbitration, we wouldn't be having this conversation. Why did they? Again, this is speculation, but in your mind, why would they not make this public agreement public?
Well, I can only, it is speculation, but also I do rely upon what the statements that counsel for the MBTA articulated during the course of Superior Court action, is that they wanted to refrain from publishing the arbitration award because they wanted an ability to have it not public knowledge why they continued their collective bargaining agreement with the Local 589. Basically, they didn't want anybody in the public looking over their shoulder as they negotiated away from what was obtained during the course of or as a part of the arbitration.
So public scrutiny would say, okay, good deal, bad deal. The public, I'm sure, would opine and have their 2 cents. But nevertheless, if they're going back to the table, knowing what's in that agreement provides context for onlookers, people perhaps looking over shoulders as to how things are going, whether the MBTA is, holding its ground or not. Now, I want to get to the crux of your hard work in the last 7 months. The agreement is made. You ask for the details of the agreement. I think you waited a week, perhaps, right? And then started your case. And I have it in front of me, as I say, the interlocutory appeal. You made three points in there. And I want, for our listeners' benefit, to hear both what the MBTA made as their case for privacy and your challenge to that. So if you will, again, this is from a lay person. There are three reasons for relief. First being the Superior Court erred in finding the arbitration award is exempt from disclosure as a document that allegedly is subject to dispute in active litigation. Well, let's take them one at a time. Why is that not a valid reason to keep this agreement secret?
Well, the issue is whether or not the document is a public record, and it's largely there's a Superior Court case law out there that, you know, the fact that a document may or may not be related to litigation, but notwithstanding that is a public record, it's still subject to publication. There's several cases out that have been published and required the whatever governmental agency involved that they produce a certain document, and whatever that might be. But here, what you're referring to is we appealed a Superior Court's decision allowing the MBTA to withhold production of the document. And one of the errors we submitted as we thought respectfully, the Superior Court judge made a mistake as a rule of law. There's a mass regulation that applies to the record supervisor. So in the public records law procedures, a person seeking a public record submits a written request for a public record, and the agency under the statute is given a 10-day period from which to reply to that request. And if they don't, or they refuse to produce a document or documents, there's an appeal procedure to what is called the record supervisor, who is a separate entity or office from under the auspices of the Secretary of State's office, William Galvin's office. And so what happens is, if we were denied, and that occurred in this case, you appeal to the record supervisor. And there's regulations that apply to the record supervisor, and one of them is that if a case is in active litigation, that the record supervisor can decline to opine on the merits of a records request. But that regulation only applies to the record supervisor. There's a whole other aspect of the statute that authorizes Pioneer Institute or Pioneer Legal, the requester, if it's denied for whatever reason, to go back to the Superior Court and get an order mandating that the record be produced, irrespective of whether or not it's in litigation. And that regulation is not directed to the Superior Court, and it has no precedential value, or does not limit the discretion that a Superior Court has to issue an order mandating that a document be produced. So that's why we argued that as a one issue, that it was wrong as a matter of law.
So what you're saying is merely because it's in dispute does not make it private. You must disclose regardless of whether someone likes it or not. You know, the document exists on its own. All right. The second point was Superior Court erred in finding the arbitration award is exempt from disclosure as a document that supposedly relates, quote, solely, unquote, to the MBTA's internal personnel rules and practices, and that the proper performance of necessary governmental functions requires that it not be disclosed. So I think what the MBTA is asserting there is this is private stuff. We don't want to like disclose what's going on, you know, how we run the show, how we manage our personnel. This is our internal matters, not for the public's eye. What would you say to that defense?
I would say it's not supported by Massachusetts law. You know, unfortunately, there's not a lot of published decision. This is what is referred to as Exemption B, but the statute says that the document shall be solely related to internal personnel rules and practices. Shortly after the enactment of the public records law, the record supervisor that I mentioned before issued a public guidance in 1978 and talked about the narrowness of that exemption. And it said in opine then it was a limited, one of limited application that relates only to documents which are concerned with subject matters such as parking facilities, lunchrooms, individual use, or sick leave. Really narrow stuff that, in federal cases that analyze the FOIA analog to this statute have come to the same conclusion. It's merely internal IR or HR type of stuff that should be and have no of minimal interest to the public that government entities shouldn't be required to apply. Where, however, a document relates not to just those matters, but other matters, including taxpayers being on the firing line for paying the underfunded pension liabilities, would construe the arbitration award as not being covered by this exemption. So that's what we argue, that that arbitration award related to and involved much more than internal or mere internal HR type of things that you would deal with employees. It had much broader implications, but unfortunately, the Superior Court did not agree with us initially.
Well, I think again, then the third point I think ties all the other points up with in a nice bow, and we've kind of already answered it, which is the Superior Court erred in discounting the strong immediate public interest in allowing MBTA riders, taxpayers, and members of the union to review, evaluate, and publicly discuss the merits of one of the proposed solutions to the problem of the MBTA's underfunded pension plan. Which will have a significant impact on our local transit system, our public spending on mass transit, and the finances of affected workers. So, you're saying, look, it's important. We need to know. It's not just academic. It's not, as you say, related to some internal minor debate about, when lunch hours are. This is $1.4 billion of public money. You say that right there in black and white that this document matters and we need to see it. Do I have I summarized that?
You did it much better than I did. Yes.
All right. So, to me, I mentioned earlier that when I read the finally released arbitration agreement, it was very, very interesting, and now everybody can indeed look at it. What as you pointed out at the top of the show, this document was finally voluntarily released. What do you think really ultimately cracked the code? You're fighting, as you say, David and Goliath. Why did the MBTA, I guess that would be the MBTA, release this information? Was it they got tired of fighting? They saw they were going to get a losing argument, or did you just get lucky, or you wore them down? What was it?
I don't think we'll ultimately ever know the answer to that story. I think probably a little bit of both. I have not. The reason for withholding, as articulated by the MBTA, was that they needed time to continue their collective bargaining agreement, collective bargaining sessions with the Local 589, and if, as and when those were concluded, they would produce the arbitration award. I know that last month the Local 589 voted to approve some form of collective bargaining agreement that abdicated some of the rulings in the arbitration award, but I have not seen any public reports about the MBTA board approving it or there being a conclusion of that collective bargaining agreement. But based upon those statements, the fact that we received the award the day we filed our single justice appeal, I would think, I'm presuming that the MBTA in some way, shape, or form has reached a point where in their negotiations with the Local 589 that they were comfortable producing the award at this point, and made that decision. So, could it be that they were trying to avoid further litigation on this because we were prosecuting the single justice? Perhaps. I'd like to think so, but I can't say with any degree of certainty what the circumstances were.
Sure. So they had, I think that's an important point. They said, look, we'll show you this arbitration agreement later on when we finally do our collective bargaining at the results, and perhaps then the public could compare and contrast, agreement one with agreement two. You got it early. Do you think in any way the public having access to this now will affect how the MBTA votes on the new collective bargaining agreement? Meaning, have you influenced the process, or merely just informed the public about what the process is?
I think we started the information process. I know Pioneer Institute recently published a synopsis of what is in the arbitration award and why any change from it may be a matter of public concern. I think it remains to be seen as to what folks that are much more knowledgeable in the pension area or involved in oversight of the MBTA, if they're armed with this information, what they can do to hold folks accountable and explain the reasons why they're making the decisions that they're making relative to this new collective bargaining agreement.
Are we entitled to the details of the collective bargaining agreement? Because I'm very curious when, if I'm the union leader and we're dealing with math, and I read the agreement, there's some challenges to what the expected return could be for the pension fund and all these kinds of minor details clipping away at the edges. But, the big gaping hole in the funding seems to be obvious. And so if substantial changes aren't made to the way the folks who pay in and take out are made, what could the union possibly have as an alternative? Are they challenging the math, or are they just saying, look, somebody else has to pay $1.4 billion in the future, not us?
I think it's the latter. I mean, they're unhappy with they want their early retirement age, and they want it to be as it was. It's a good deal, so why try to give it up or hold on to it as long as and as hard as you can? I know the collective bargaining process is meant to be behind closed doors. Those are not subject to public scrutiny. But if, as and when the MBTA board holds a meeting for the purposes of ratifying any collective bargaining agreement, those terms should be discussed in a public meeting, and questions I think could be asked of the board why are they acting in a certain way when we have this arbitration award that says otherwise. If they're going to approve, for instance, the lower retirement, or yes, they allow the lower retirement age that was set forth in the arbitration award.
Now, in the court of public opinion, which I think we all live in, it seems to me, on this podcast, look, I'm a hardcore city mouse. I use the T, and I won't say I love it. It's not good, but I keep rooting for it. And we've had guests on who said, look, the problem with the T didn't start today or yesterday or a week ago. It's a long history of neglect, and it's trying to dig itself out of this massive hole of deferred maintenance and all kinds of problems. That said, wouldn't the MBTA want to, in the court of public opinion, seem to be as forthright and as cooperative and as above board as possible? In other words, shouldn't they be making their own case, saying, look, we've got problems, but we're doing our best in the light of day to fix them in a sincere, honest, and well-intentioned way? What possible benefit could trying to keep their negotiations secret at the risk of undermining the public's faith in them? This has to be both, regardless of the findings of the arbitration, keeping secrets from the public is not going to win you hearts and minds for people who are pretty upset with all these delays and crashes and, what's going on? Like, are they blind to this, the optics of this particular case?
I think the lack of transparency is endemic with our state and local government, and I think it's just in an ideal world, Joe. Yes, I mean, I think if they were really want to burnish and polish their perception within the public, a new day has arrived and we are going to be transparent. We're making these decisions relative to the pension agreement for X, Y, and Z reasons. And they would explain themselves in an open and honest fashion as to what is occurring. So we can make informed decisions and either jump on board or not. I just think it's institutional inertia. This is how it's been done for years and years and years and years. And it's going to take a constant vigilance on folks of public interest law firms and the like that are going to keep on having to litigate newspapers and Boston Globe, Boston Herald, all seeking this type of information and holding governmental and institutions to the standards of the public records law. And it's a ongoing and frustrating process because it leads to a lot of delays and inefficiencies. But I agree with you. It would be better if they were to say, here's the arbitration award. This is the collective bargaining agreement we reached. We reached these decisions because of X, Y, and Z. I haven't seen that yet, but it's going to require some type of questioning by somebody's part to see what the rationale is for the new collective bargaining agreement.
Well, your answer kind of takes us a full circle to where we started, which is what is Pioneer Legal all about, or why is legal advocacy for the little guy, in this case, I suppose the taxpayers, the little guy, why is it so important? And I think this case illustrates what's going on. Now, as you mentioned at the top of the show, you didn't win a legal argument, but rather the information was voluntarily disclosed, but perhaps owing to the pressure applied by your legal challenge. Was it really just this one piece of arbitration you were trying to get, or does this help set a precedent for future disclosures? In other words, there may be a future arbitration agreement by the MBTA and its union in the future. Do you think your work and the work of this case will pave the way either for the MBTA to release it outright when it should, or for a judge to say, look, send Pioneer what they want because public record laws require it? So are you trying to set a precedent for more ready access to public records?
Yes. I mean, whether we can do so within the context of the current litigation and get further appellate review remains to be seen. We're looking into that because there was an argument that the voluntary production of the document somewhat moots the case, but there is some other case law that allows us to seek further appellate review if we choose to. But yes, I mean, it's this type of vigilance and it's this type of adjudication, holding people's feet to the fire, if you will, on the public records law, that we hope to get more judicial awareness of the abuses and get some published decisions that would assist Pioneer Legal or others in the area have a clear, defined guidepost as what's permitted, what's not permitted under the public records law, and hopefully get more the state and federal government to be more transparent as a result of that.
So even though this case is theoretically mooted out, you may be able to have further appeals that can, let's say, memorialize the principles and the precedents you've established with your work. Is that fair?
That's a fair statement.
Yeah. Okay. All right. So we're getting to the end of our time together. So this is not the only work you're doing. This is not the only case that Pioneer is doing. So if we've piqued the interest of our listeners about your advocacy for transparency and public record access, where can our listeners learn more about your work, your legal work? Again, we've had Judge Bailey on as a guest, but where can we learn more about your work and Judge Bailey and others at Pioneer Legal?
We have our website, pioneerlegal.org, which we in a newsletter that we publish on all the different active cases that we're involved in. Proud to have, we've had some really nice outcomes in the recent past at the SJC on some tax cases and a free speech case where the Supreme Judicial Court of Massachusetts found in our favor. Last week, we were on amicus brief. I'm sure you've seen the headlines of, grandma lost her house to a tax foreclosure in Minnesota. That's the Tyler case that was argued in the United States Supreme Court on a tax taking. We have an amicus brief in that case as well. We have a similar couple cases here in Massachusetts that's pending in the United States District Court against the town of Bolton, and another pending in bankruptcy court representing a woman that was foreclosed upon, lost all her equity in a house when she, for a really nominal amount of real estate taxes, but literally lost hundreds of thousands of dollars in equity in her house as a result of the tax taking. And then we're trying to right that wrong, if you will. So we're being very active, and we're blessed with a very good team that's been working hard to accomplish our goals.
Good. Well, by my reckoning, you're batting 1,000. I'm going to chalk this, even though it was a voluntary compliance or voluntary release. This was a definite win, not just for Pioneer, but for all taxpayers and people who take an active role in sort of scrutinizing the work that public officials do on our behalf with our money. So thank you very much for joining me today, John. This is a complex topic, but for our listeners who hung on, I think they were rewarded. And of course, they can learn more about your work if they want to dig more deeply. So thank you for being on Hubwonk, John.
You're welcome. My pleasure, Joe. Nice speaking with you.
This has been another episode of Hubwonk. If you enjoyed today's show, there are several ways to support Hubwonk and Pioneer Institute. It would be easier for you and better for us if you subscribe to Hubwonk on your iTunes podcatcher. It would make it easier for others to find Hubwonk if you offer a 5-star rating or a favorable review. If you have ideas or suggestions or comments for me regarding future episode topics, you're welcome to email me at hubwonk@pioneerinstitute.org. Please join me next week for a new episode of Hubwonk.